tuned in to the Andrew Lawton Show.
I want to go into a bit more of a newsy topic here. Yesterday, the injunction that the University of Toronto sought to dismantle the anti-Israel encampment on campus was granted. And this means that as of today, police are going to be moving in. They've said they plan on enforcing this injunction. I want to talk about this from a constitutional liberty perspective here and also the broader implications. Josh Dehaas returns to the show. He's a lawyer with the Canadian Constitution Foundation and one of the hosts of their tremendous podcast, digging into many of these issues. Josh, good to talk to you as always. Thanks for coming on.
Great to be here. Thanks, Andrew.
Let me just start with the first, the glaring question here of why an injunction was even necessary when you had what, I mean, at its core was a trespassing issue. Like, presumably if someone were to set up a camp on my front lawn, I could call the police without going to a judge and say, please remove them. Why did it need to go to this stage?
Yeah, so it's a good question. It's a question we've been getting a lot because, police can enforce trespass laws. And this was very clearly a trespass from the beginning. Trespass just means going onto somebody's property without lawful justification. And there's an old English case that says merely bruising the grass is going to count as trespass. So what you had here was people, deciding who was allowed to go into this space on campus, right in the center of the University of Toronto. And you had to, pass a series of questions to sort of get into this encampment. So it was just quite obvious it was a trespass. And, in York University in Toronto, as you well know, Andrew, police just went in and enforced the law against trespass the day the encampment was set up. So what I think happened here was basically U of T decided that they were going to negotiate and that they were going to let this encampment sort of fester for at least a short period of time before they decided to, seek legal action. And the protesters had an argument, which was essentially that they have freedom of expression rights protected by the Constitution, freedom of assembly rights to use this otherwise private property at U of T. And they had just a little tiny bit of an argument, which was that this free speech directive that Doug Ford had put in place in 2018 somehow meant that after decades of law in Ontario saying the charter doesn't apply to these types of university actions, that all of a sudden the government had decided that they wanted it to apply. So I think Toronto police looked at that and they said, okay, there's some legal uncertainty here. And you had law professors out there sort of siding with the protesters saying this directive means that now the charter does apply to campus. And just based on that legal uncertainty, I think they probably had advice to wait and see what happens with the court case. And not all that surprisingly, the injunction has been granted.
Just as an aside, I think it's a bit rich that these protesters, many of whom have called for, any professor associated with Israel to, be sent to the gulag, are all of a sudden these newfound defenders of academic freedom.
Yeah, and a lot of these people are the same people who, they would have canceled just about anybody involved with the trucker protest if they tried to speak on campus a few years ago. I remember if there was any talk about race or gender that didn't align with sort of progressive shibboleths, they would go on campus and pull the fire alarms and try and get people try and get their expression shut down. So
but all of a sudden Doug Ford's free speech directive might not be such a bad idea for them. Does it, from a legal perspective, does it have any bearing at all on whether they are students or faculty who generally have, I think, a right to use the campus?
From a constitutional perspective, I don't think it has really any bearing on it at all. But a lot of this case was decided based on University of Toronto's own policies, and they have, use of space policies and speech policies. And I think under those policies, they are going to, they care a lot more about what professors and students are doing because that's part of their mission, right? So under those policies, it might matter that they're students or that they're professors, but from a general constitutional law perspective, it doesn't really matter all that much. And frankly, the respondents in this case, I think most of them, if not all of them, were students.
Have we gotten to a point, or I maybe this is a stupid question because it sounds self-evident as I'm formulating in my head, but what I was going to ask is, are these policies just so far from being content neutral in that, like, the way these things are enforced in any academic freedom context, in any public assembly context on campus, depends entirely on the specific expression and rather the fundamentals?
I think that was certainly the case up until fairly recently, but I think the whole debate about expression and academic freedom on campus that arose after October 7th really woke a lot of people up on the sort of the progressive left, who tend to be the people enforcing these policies, that they need to be a little bit more principled about these things. So I think that's sort of the silver lining here, is that, if you go back 3 years, 5 years, there was a lot of shutting down of legitimate speech and legitimate academic research and lectures on campus. And I think we're going to see less of that, hopefully, going forward, because I think people might have learned their lesson this time around, that it's not just, right-wing voices that are being canceled, but also that sometimes there are, pro-Palestinian voices that are more closely associated with the left that get canceled, and that we want to have the same rule for everybody, so that rule will be there when we need it.
Obviously, police. I mean, like we saw with the Freedom Convoy, police were really trying to get people to just leave on their own volition, and it didn't really work too well. They're trying to do the same thing here, but the protesters have basically said they, have no interest in packing up and going home in a lot of cases. And there's always the possibility that something like this is the Streisand effect, where now more people will descend on it. So this could be very messy as things go on. If someone doesn't leave, what are they facing right now? Is it the, $70 trespassing ticket?
I think it's more serious than that, to be honest. So if people don't leave, and I noticed there was a union, CUPE Ontario, that's encouraging people to go down at 3:30 this afternoon and join the protest. And, this was the union whose head, Fred Hahn, famously said he was going to use his own body to, stop this protest from getting shut down. And if the deadline passes, which is 6 p.m. for people to leave, and people are still there, we don't know what time it's going to happen, but we do know Toronto police are going to go in and enforce that. And that means they're going to physically remove people, and people will be thrown in jail potentially. And a lot of them will face potentially even contempt of court charges, depending on how serious that is. And that's a really big deal. Like, you will, you can go to jail for a serious amount of time for contempt of court. So I think it's really kind of irresponsible to encourage people to stay at this point, when the protesters had their day in court. They got to make all their arguments, and now it's time to respect the rule of law, in case there was a lack of clarity before that you were trespassing, that you didn't have a right to be there.
If someone is charged, does that constitutional question then, if they choose to go that road, really start again? And do they, get to, in their defense, basically try again with the whole, no, I had a constitutional right to be there?
I don't know how much bearing that would have on the actual contempt of court, but yeah, if there was a trespass charge, they'd probably be able to make, charter arguments again, and who knows how that will go. But I mean, the fact that the judge just took a very detailed look at this, this is an injunction decision. An injunction is just, what's going to happen until we can hear the full hearing in a way that avoids irreparable harm. That is normally a pretty short decision. This is 98 pages. Like, the judge took, 2 days of hearing people out. There were all kinds of interveners that submitted arguments, and the judge really meticulously went through the evidence. And there was a lot of evidence on the record already, and the law, and came to a conclusion. So I think that would be highly influential to any other judge that has to consider, whether there's a charter issue here.
I know there are obviously different courts in different provinces, but where did this judge diverge from, apart from on the decision, from Quebec, when the injunction request against McGill was rejected?
Yeah, so the big difference here is when McGill was asking for an injunction to get rid of their encampment on campus, they did that. What they were seeking was called an interim injunction. And that is something that's basically like, you're saying there's an emergency and we need to go to court today or tomorrow or the next day. And the other side, they don't really have a lot of time to build their argument and put together, affidavits and evidence. And so if you're going to court and saying this is an emergency, you need to shut this down right away, that's going to be a really high bar to get over to convince a judge that we have to end this thing right away. And that's different than what happened here, where, we're more than a month into it before U of T initiated these proceedings, and the judge gave them weeks of time to get their evidence together. So we have a much fuller record. And so the judge can feel confident saying, yes, there's a strong prima facie case that U of T is right here about the trespass. And I think that's the main difference, is just that what McGill was asking for was sort of an emergency injunction. And this is something that's a little further down the line with better evidence and arguments.
Fair enough. Josh Dehaas, lawyer with the Canadian Constitution Foundation. What's coming up on the podcast?
Oh, well, we'll be talking about this. We're going to be talking about sanctions against the Quesnel, BC mayor. He's now suing City Council because they sanctioned him for his choice in books.
Not even. It was his wife's choice in books.
Well, there's a little bit of dispute about that. So, at the beginning, it was his wife who was handing out this books, and the book's called A Grave Error. I believe True North is involved in that book. Mm-hmm. And it originally was his wife who was handing out this book. And I think everybody was asking, what does this have to do with the mayor's job that his wife is handing out this book? But I think he does admit at some point that maybe he did try to recommend this book to a couple people. Ooh, oh no, he recommended
the plot thickens.
And he may have even said at some point that it should be in the public library, that people should be able to access a controversial book in the library.
Yeah, you can't say that in this day and age, that a book should be in the library, heaven forbid. All right. Well, we look forward to that, Josh. Thanks for coming on as always.
All right. Thanks a lot, Andrew.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.